Again, my name is Heidi Kippel, and I'm an estate planning attorney. And today we're going to talk about being a fiduciary and what being a fiduciary entails. So, in the estate planning world, when you are named as a fiduciary, that means that you have agreed to act as somebody's financial advocate or as their medical advocate. So, when you create an estate plan, there are three documents that involve finances. One is a trust, and the fiduciary in a trust is called a successor trustee. And then in a will, the fiduciary is called an executor. And in a durable power of attorney for financial affairs, that title is called an attorney in fact. The medical directive names a medical advocate, and they're often referred to as a healthcare agent. So when you create an estate plan, when a person other than you is making your financial and or medical decisions, when that person agrees to take on that decision responsibility, they are acting in a fiduciary duty. So what a fiduciary duty is, it is a legal duty imposed by the state of California, and the standard is when you make a third party's financial or medical decisions, you're expected to make reasonable and informed decisions and to make similar decisions that a person in reasonable circumstances would make. So, for example, if my brother sadly were to become incapacitated, and if I was his fiduciary for financial affairs, my job would be to step into his shoes and basically be his bill pay advocate. So my job would be to use his checking account to make sure that his mortgage is timely paid, his homeowner's insurance is paid, his car insurance is paid, his state and federal income taxes are filed and paid. So when you agree to be a financial durable power of attorney, and while a person is alive but incapacitated, your job is to step into their shoes to put those financial assets in your name, whether it's in a trust as the acting trustee or whether it's as the durable power of attorney. So there are two different occasions while a person is living when this can occur. The first is I could voluntarily make my trust and my durable power of attorney to give a third party powers over my financial decisions effective immediately. So for example, oftentimes I'll have clients come in and they're starting to get up there in age, their physical limitations are starting to present themselves. Maybe they're not as mobile, maybe they're not able to drive as easily as they used to be able to do. So if I'm, for example, a 95-year-old woman whose mobility is starting to decline, whose eyesight is possibly starting to decline, and I decide that it's time to start teaching my adult child about my finances, what my monthly bills are, how I pay them, when I pay them, how much they are, I could name my daughter as what's called a co-trustee. If my daughter agreed to be my co-trustee, then her and I would sign documentation that would be me nominating her to act and her accepting and agreeing to act effective immediately. And then we would take those documents to all of my financial institutions, and then my banks and other financial institutions would then add her onto my financial accounts, and her and I would have the ability together or individually to deal and manage my month-to-month bills. So when my daughter is acting in that fiduciary capacity, she would have to use my monies the way that I typically do. So what she couldn't do, for example, is if she were short one month and needed money to make a car payment, she couldn't take monies out of my trust account to pay her personal bills, because that would be a breach of her fiduciary duty. She's also under a fiduciary duty to make reasonable and informed decisions. And what that means in plain language is when it comes to managing and investing my finances on my behalf, she pretty much has to make all decisions middle of the road. So she can't be too high risk in her investing. She can't be too low risk in the investing, but she would need to be right in the middle as far as being not necessarily conservator, but in the moderate investing area. And sometimes people will call me and they're concerned because they don't want to make bad financial decisions on behalf of a loved one. And these documents always give you the ability, not that you are legally required to, but you could seek professional assistance in doing these duties. So for example, if my daughter felt more comfortable talking to a financial advisor about the management and diversification of my assets, she would be able to do that. But again, what my daughter couldn't do is she couldn't use my monies to pay her personal bills, because when you agree to be a fiduciary for somebody, what regardless of what your relationship is, whether it's your spouse, whether it's your parent or your adult child or your best friend or neighbor, you are agreeing to make those reasonable and informed decisions. And you're also agreeing to not use those monies for your personal gain or for your personal bills. And one of the things that we recently dealt with is we had a client who was her sister's durable power of attorney because her sister had lost her capacity, which is the second scenario where these powers can be given while a person is alive. And basically the client was incapacitated, and her sister on her behalf started using her monies to give her sister's kids gifts. And luckily, somebody in the family called us very concerned because apparently the incapacitated individual wasn't in the habit of giving gifts. So I ended up basically having a conversation with the durable power of attorney, asked a couple of questions, and then explained to her that one of her jobs is to preserve these assets for the benefit of her incapacitated sister. And even if in her heart of hearts she meant well by giving her nieces and nephews gifts to help pay for their car insurance and what have you, that technically would be deemed a breach of her fiduciary duty. So even though she had very good intentions and she was trying to help her sister's kids with the car payment and a missed rent payment, technically those aren't the type of things that these documents would have allowed her to do unless they specifically had language saying that she could make monies to an incapacitated kids for those purposes. Because if I were to become incapacitated, my successor trustee and durable power of attorney's job is to basically to conserve and preserve these assets to make sure that there's sufficient monies available to pay for my care through my end of life. Do is use these monies to make sure that my kids have a nice Christmas or holiday. So anyhow, I think we've made that point, so I'll move on. So when we work with clients in setting up an estate plan, oftentimes, I'd say probably 80% of the time, we write estate planning documents to give these fiduciary powers only if and when a person were to lose their capacity. And then that is when the documents would spring into effect. But the way that these powers are obtained is by the loved one who's named in that document obtaining two separate notes from two separate physicians stating in the physician's opinion that the individual is indeed incapacitated. So if I have an estate plan and if my husband has passed and I'm now a widow and a single woman, and if my estate plan names my adult daughter to be my successor trustee and durable power of attorney, and if I have now been diagnosed as no longer having the capacity, which means I no longer have the ability to manage my monthly bills, then once my daughter takes me to two separate physicians and gets two separate statements in writing from physicians stating that in their professional opinion, I don't have the capacity to manage my financial affairs, then that's when these documents spring into effect. That's when my daughter would take the documents plus the doctor's notes to the financial institutions, and then they would take my name off of my accounts because I'm no longer legally able to be a manager of my finances, which is actually a good thing because that's going to protect me from myself. Sadly, elder law and elder abuse is the #1 crime in the United States, which is really sad. And this tends to be a pretty common area of how these crimes play out. Oftentimes you have adult children that sadly unduly influence their parents and kind of bully them into giving them monies because they're taking their parent to the doctor, or maybe they're making some dinners for their parent, but sadly, I see this happen quite often. But going back to my example, if I have a durable power of attorney and a trust that states that I give these powers only if and when I lose capacity, then once my daughter has those doctor's notes, then that is the point in time where she would have my legal permission to step into my shoes and be my financial advocate. As I mentioned earlier, the other 10% of the time when I draft these documents, I will draft the documents to give the powers effective immediately. The benefit of that is sometimes I've had clients that are leaving the country for a prolonged period of time and they're fully capacitated, but they're out of the country. So they want to have a loved one who's in the United States paying their bills and dealing with their assets so that while they're outside of the United States, they don't have to have the trouble of managing that. Luckily, with computers and online banking, being outside of the United States and managing your monies is far more easy and accessible. So I draft those types of documents less often. But sometimes I'll have occasion where people might be going on a long vacation or they might be out of the country, and they'll actually have me draft a durable power of attorney to give a third party their permission to get veterinary care for their pets. So there's a myriad of reasons of why people might use these types of documents. Another time I had a couple that was leaving the country for work. It was kind of a sudden thing, and they were in the middle of refinancing their home. So they had me do what's called a limited durable power of attorney, where they gave a third party the very specific limited power to sign the mortgage documentation on their behalf while they were outside of the country so that the refi could close. But that saved them from having to go to an embassy in the other country and talk to a notary and get all the documents handled outside of the United States. So there's a lot of different occasions for people to put a third party in charge of managing their assets, but most often it occurs when a person is living but has lost their capacity, and it also occurs when a person is wanting to have somebody come on and help them co-manage their assets. I will say that I am a big proponent of when you start getting to a point in your life and you feel that things are maybe starting to slow down, or you're not as mobile, or maybe your memory isn't as sharp, or maybe the number side of managing assets isn't as easy. While you have capacity, that is the ideal time to be bringing on a third party as your fiduciary, because it is so helpful for you to be able to teach them while you have your capacity about your day-to-day financials. You know, what bills do you have? How do you pay them? What's your login? What's your password? Because those are things that most of us don't spend the time to memorialize in writing, and getting passwords and trying to figure out banking, online banking, when a person has already lost their capacity without having that information handy and available to your loved one. It's a real time consuming process to get up to speed on all of that. So I know that when we do our estate plans for clients, one of the things that we include in our estate planning binder, which is an optional, I call it homework, but it's an optional item of homework, is we give clients the ability to write in all of their financial information. When do they pay their mortgage? How do they pay their mortgage? Do they pay it automatically through the bank, or is it something where they write a check? And I do encourage clients, and I do this myself with my own personal financial affairs, to review that document at least once a year, because accounts change, account numbers change, banks buy and sell and merge with each other. Sadly, some go out of business. So keeping that information current and up to date, especially when it comes to logins and passwords, is also key. And having that information in your estate planning binder with your estate planning documents just makes that transition so much easier for your loved ones. And frankly, it doesn't take a lot of time. So I have it on my calendar as a January 1st item, because my husband and I aren't big New Year's people. So on January 1st, we basically every year get up. This is how boring we are. We get our coffee. My husband stands at the file cabinet. I make notes. I have a master copy of this document that I keep blank intentionally. So every year I run a copy of it. So I have a fresh, clean copy. And he tells me, you know, what our bills are, how they get paid, the account numbers, the logins, the passwords. And every year we have new and current financial information in our estate planning binder. And we do that with the specific purpose of making sure that if we're hit by a drunk driver, which is never planned, you never know when these situations are going to happen, we'll have that transition be a lot easier for our loved ones during an already difficult time. So for those of you who have an estate plan, if you haven't done this, if you haven't prepared some kind of a memorandum memorializing your financial information, I would encourage you to do that. I would also encourage you to put that on your calendar as a reoccurring event, so that every year you're going through that memorandum, you're updating. Your password should be changing on a pretty regular basis, and that by itself is a reason to need to update that document pretty regularly. Some people do it quarterly. I do it once a year. And then the other thing that I do is with our estate plan, there's a binder right next to it. And I keep all of our year-end statements in that binder. So our checking account, our money market account, our investment account, our retirement accounts. I have a copy of our marriage license, birth certificate, credit cards front and back, so that if our wallets were stolen, we'd have our credit card information, the account numbers on one side of the credit card, the phone number's always on the other side of the credit card. I also keep our homeowners policy off, a copy of it here at my office, because sadly, when Scripps Ranch caught on fire many years ago, a lot of my clients that lived in Scripps Ranch weren't sure whether or not their homeowners insurance was going to cover the cost of them staying at a hotel. So many of them were asking family and friends if they could stay the night, and they were surprised at how slow their insurance company was to provide them with that information. So keeping a copy of your homeowner's insurance and your credit card information and all of that in a safe place is very important. But I keep a copy with our estate planning binder in our house, and I have all of that same information scanned on a flash drive, and I keep the flash drive in our safe deposit box at the bank. So I know that that's in a secure place. The safe deposit box, as far as I know, is fireproof. But one thing people don't realize is nobody has yet to invent a fireproof, waterproof safe deposit box. So if a bank were to catch on fire, there is a very good possibility that if the fire department gets there, a lot of the things like a flash drive would not be salvageable due to a fire if there was water damage to it. So I'd like to mention that, just full disclosure, you can never be too careful in keeping things protected and keeping things in a safe place, and preferably in maybe multiple safe places. I know some people will keep those important documents secured at their office as a third location to keep it. So anyhow, just having said that, the other time that a person becomes a fiduciary is when a person passes away. So when we write a trust, generally speaking, if a person is living and has capacity, there's a very good possibility that their trustees won't need to make the decision as to whether or not they're able or willing to be a trustee until that person passes away. And one important thing that I neglected to mention is in all of these documents, whenever you name a successor trustee, you are just nominating them. So if I named my adult daughter as my first choice successor trustee, and if life was happening and maybe she was having a child and said, gosh, this is a really bad time, she can always decline that nomination, in which case it's always good in these documents to have at least 3 to 4 people listed. You want your first choice, second choice, third choice, fourth choice, because there is a possibility that if your first choice says, gosh, this isn't a good time, and they decline, thank God you've got your second choice listed. But all of these documents also have language where a person is incapable of being a financial advocate if they lack capacity at the time of acceptance. So on the flip side of that example, if my daughter's not willing to be my trustee, and if I have my dad listed as my second choice trustee, and if hypothetically my dad no longer has capacity, then he's no longer eligible to be my trustee, which again, that's for my protection and his protection and the protection of my estate and my beneficiaries. So there again, that's why it's good that I've got a third person listed. So if the third person listed is hypothetically my sister, and if she agrees to be a trustee and she's moving along, but then sadly life happens and now she needs to step down, all of these documents do have flexibility of resignation built into them. So if my sister needed to step down and resign as the trustee, that again is why we're happy that we have 4 listed, because fingers crossed that 4th person listed is willing and able to be a trustee. Now I have a trustee, everybody's happy. And let me explain now what they do after you pass. So when a person is a fiduciary and they are your financial advocate after you pass away, there is something called trust administration that occurs. So the majority of people in California do have trusts, and that's because they own real property, because California has a law that if you own a house and if it's not titled in a trust and you pass away, then your real property would go through a court process called probate. And one of the reasons why many people in California want to avoid probate is because the fees are very excessive. And the reason the fees are excessive is because they're statutory, which is a fancy way of saying that they're predetermined by law. And the fee is based on a calculation of the gross value of the asset. So oftentimes when we've handled probates, we've had fees that have ranged anywhere from $15,000 to $50,000, upwards of $100,000, just depending on the gross value of the assets before the probate court. So one of the things that a trustee has to determine first off is whether or not an estate is subject to probate. So typically when we get hired to help with the trust administration, the first thing I'm going to ask a trustee to do is to gather the title of all the decedent's assets. So I want to see their investment statements. I want to see the checking statements, the savings statements. The reason I want to look at all the financial statements is because I want to ascertain what assets are titled in the trust and what assets are not titled in the trust. So one of the first things that a fiduciary has to do when a person dies is to make the determination as to whether or not a probate is needed. And let me just caveat that statement by saying that all states have different laws. So everything I'm talking about during today's presentation is specific to the state of California. In California, if I owned my house and even if I had a trust, if my house wasn't titled in my trust at the time of my death, that would trigger probate. So you can still go through probate even when you have a trust, because it's how your assets are titled when you die that determines whether or not that court process is legally required. And that's why at the first meeting with the trustee, the first thing I want to do is go through all the title documents to the real properties, and I want to look at all the financial statements. So when you have a house that's titled in a trust, it avoids probate. If you own a timeshare, you need that titled in a trust, so it would also avoid probate. And then when it comes to the liquid, not taxable assets, not retirement assets, those assets either need to be titled in the name of the trust to avoid probate, or they need to have living beneficiaries attached to them, or preferably they'll name the trust as the pay on death beneficiary. In California, if I had a bank account in my individual name, and if I didn't have a beneficiary tied to that account, if you took that account plus any other account like it, and if you took their aggregate net value, and if all of those accounts added together exceeded $166,250, then those assets would trigger probate. So when you create a trust, creating the trust is really a two-step process. The first step is talking with the attorney, getting the documents drafted and getting the language in the documents exactly the way you want. And then the second step is updating the title of your assets, because when you're a homeowner, a deed needs to be prepared and recorded that transfers the house into the trust. When you have assets, liquid assets, taxable assets, bank accounts, checking accounts, investment accounts, those assets either titled in the name of the trust, or you need the trust named as the pay on death beneficiary, and that's how those assets avoid probate. But retirement assets are the one asset that doesn't name the trust as a beneficiary, and that's for tax reasons. So when you have a retirement asset, you want people or organizations named as beneficiaries and not the trust, because if you name the trust, you're going to create an unnecessary taxable event to the beneficiaries of the trust. And for those of you who have an estate plan that maybe set up their estate plan 10 years ago or later, just know that 10 years ago, we advised all of our clients to name their spouse as their primary beneficiary on all of their retirement assets. And we used to advise clients to name the trust as the secondary beneficiary, because 10 plus years ago, that was okay. But now you fast forward to 2022 and we give the opposite advice now. So for those of you that haven't reviewed your retirement beneficiaries in a while, I would encourage you to go online, because I think it's that easy, and just look at who your beneficiaries are. If you're married, you want your spouse as your primary beneficiary and your children listed second. If you're not married or don't have children, you want to make sure that you have a loved one or loved ones listed as a primary, and then you want to make sure you have a secondary. If you're able to name 3 beneficiaries, that's even better, because you're not going to run out of beneficiaries. But if hypothetically you did run out of beneficiaries, and if the value of that asset plus any other one that doesn't have a living beneficiary attached to it, if all of those assets added together exceeds that $166,250, then those assets would trigger probate. So When a person hires us because a loved one has died and they have agreed to be that person's trustee, one of the first things that we have to determine is whether or not we have a probate to initiate. 9 out of 10 times there's not a probate, because thankfully when people do their estate plan, they take the time to make sure that their assets are correctly titled. And that's why the majority of people who die in our state don't have a probate, which is good. You want to avoid probate because it is public. So everything about you and your loved ones is public. So anybody can pull your file and see how much money you had, what your debts are, who your beneficiaries are, where your beneficiaries are living, how much money they're inheriting, their date of birth, social security number, current address. All of that information is part of that public process. So avoiding probate in today's modern world of identity theft is critical. And the way you avoid probate is to have all your assets properly titled. So having a trust isn't enough. You need to have the trust and you need to have your assets properly titled to make sure that you avoid probate when you pass. So in this presentation, we're going to assume that there's not a probate required, because that's its own separate topic that would probably take me an hour to go through and explain. But I will tell you that the probate process is very similar to the trust administration process. The difference is the probate process involves a judge and attorney or personal appearances before the judge and lots of paperwork that you turn into the court. So now we've determined that there's not a probate needed because the decedent had all of their assets properly titled. So then the next thing that the trustee has to do in their fiduciary obligation is they have to provide notice. So when a person passes away, all of the people that are named as beneficiaries in their trust are entitled to this legal notice. And then their closest living blood relative is also entitled to legal notice. And I'll explain in a second what that means. The purpose of the notice is to let your loved ones know that you've died, because not everybody always knows that a loved one has passed. The other purpose of the notice is to tell them who the person is who's acting in this fiduciary capacity, who is the trustee, what is their telephone number, and how does a beneficiary contact them. And then whenever we do trust administrations, I always encourage the trustee to send with that notice a copy of the trust and any amendments thereto, in addition to sending a copy of the will and any codicils thereto, because under our state law, if you don't send those documents, any of the people receiving notice can always request them. If you send the documents with the notice, then you've opened and closed a statute of limitations for beneficiaries to contest the estate. And when you send the documents, there's only a 90-day period to contest the estate. If you don't send the documents, and if anybody requests them, then that notice of statute of limitations is extended to 120 days. So it's always better to send the documents, because one, the beneficiary is entitled to read them. So why not send them? Because everybody should have the ability to read the trust and see what it says. And two, it also shows the beneficiary's transparency, in my opinion. So when you are acting in a fiduciary capacity, to me, one of the most important things to start off with is clear and concise communication and transparency. You want the beneficiaries to know that you are happy to answer questions, you are available. One of your duties as a fiduciary is to treat all beneficiaries impartially. I have had occasion where I have helped trustees administer trusts, and there's some pretty bad family dynamic, and I'll have had trustees that basically say, I'll talk to this beneficiary, but I'm not going to talk to that one. And then I have the job of letting the trustee know that as a fiduciary, one of their duties is communication, and they have to treat all beneficiaries impartially. So you can't do that. You can't say, I'm going to talk to one and not talk to the other, because if you did that, you would be in violation of your fiduciary duties to the beneficiaries, and they could take you into court, and the courts don't like that. And chances are, court, if you were found to do that type of non-communication with the beneficiary, they would, in the judge's discretion, have the ability to remove you as a trustee. So being a fiduciary is not an easy job. It's not one to be taken lightly. It is one that my advice to anybody who is in a situation where they have the ability to become a fiduciary or not, I would counsel someone to make sure that they've read the documents, to make sure that they understand what the duties involve. Sometimes understanding the players is helpful too. I know we have turned down a few trust administrations, with all due respect, because I was privy to who some of the players would be. And frankly, I didn't want to deal with unnecessary drama. And sometimes things are going to be litigated because people litigate when it comes to these things. And oftentimes the litigation is not because of anything legal, it's more from an emotional point of view. And that can get expensive and that can cause things to drag on. And so for those reasons, I will tell you that I would not just be a trustee for anybody. And if you were in a situation where somebody named you as a trustee and now you have to make the decision as to whether you want to accept that or whether you want to decline it, because you can decline it, I would make sure that you've read through the documents, you understand what the documents impose on you as far as your duties managing monies. I would make sure that you are pretty familiar with who the beneficiaries are, so you know who the players are, because sometimes you don't always want to just get on any ball field with any player. And other times it's not a problem, but in every situation it's different. So some trust administrations we've done are super easy and straightforward, and we get through them very quickly. And other trust administrations just go on because you might have somebody who's not communicating or who's not very responsive. But anyhow, so in this presentation and talking about fiduciaries, we have gotten to the point where a loved one has died, you've agreed to be a trustee, you've determined that there's not a probate needed, you have sent out the notice to beneficiaries. So the notice has to go to every single beneficiary that's named in the trust. And then I mentioned earlier that the notice also has to go to the decedent's closest living blood relative. So hypothetically, if I had a client who had 3 kids, but they disowned one and was only giving their estate to 2 of the kids, under California law, the 2 beneficiaries named in the trust are required to receive notice because they're named beneficiaries, but that 3rd child would also be legally entitled to receive legal notice because they are the closest living blood relative, being a child of the decedent. So it is important to know that when you pass away, sometimes people with estranged relationships think that some things can be kept secret, but legally the beneficiaries of the trust are entitled to notice and your closest living blood relative is entitled to notice. So if I died and if I'm married, my husband would be my closest living relative. If he wasn't living, then my children would be deemed my closest living relative. If any of my children had passed and if they had children, they would be deemed my next closest living relative. And if I had no living lineal descendants, we go back up the family tree to my mom and dad or surviving parent, then to brothers and sisters, which includes half but not step. And then we go to nieces, nephews, great nieces, great nephews, grandparents, aunts, uncles, first cousins, second cousins. So the family tree, as you can imagine, is the whole gamut of going sideways, down, and then up. So once you've sent the legal notice, it's important to know that legally you're not going to make any distributions of trust monies until you've gotten to the end of the trust administration process. So it really surprises me sometimes when a person dies and then they get the notice from our firm and then the phone calls start coming. How much money are we going to get? When are we going to get it? And I have to explain to beneficiaries that when a person dies and when you're a fiduciary and you're administering a trust, it is a process. So a trustee's primary job is to first pay all the bills of the decedent, which includes paying the mortgage, closing the credit cards, paying the credit cards, paying any final hospital bills, funeral bills, memorial bills. And then the trustee also has to meet with the decedent CPA to make sure that the taxes are current and up to date and get ready to file that year's taxes and possibly the next year's taxes in case a trust is going to take a couple more months and go into the next year and be administered. So for all of those reasons, when a person passes away, I would say on average, it usually takes anywhere from 3 to 6 months to administer the estate from start to finish, because the next thing that the trustee is going to do is now they're going to look at the trust and see who all the beneficiaries are. They're going to look for the part of the trust that talks about the tangible personal property. The tangible personal property is all the stuff inside of the home. We have very specific language in our trust about how that gets dealt with, just to make sure that that's as easy of a job as possible for the fiduciary, because honestly, going through a loved one's house and trying to decide who gets the couch and who gets the dishes is a very time consuming process. It's probably the one part of being a trustee that, if trustees were to be honest, it's the one part of the job that's probably the most time consuming and probably the most stressful, because sometimes you're going to have a situation where you've got two different beneficiaries who both want the same thing. And sometimes you're going to have a situation where maybe a beneficiary wants the same item, not because they necessarily want that item, but because they don't want their loved one to get that item because it's an emotional thing or it's a personal thing, or mom bought you a car and she never bought me a car. So one of the other difficult things about being a trustee is the emotional side that comes into play, because sadly, my experience after practicing estate planning for 22 years is when a person dies, their loved ones oftentimes aren't always on their best behavior. And that's oftentimes when people's true feelings surface, and it can get kind of ugly. So we've had a lot of very straightforward trust administrations, and we've had a couple that have just dragged on because of the family drama, which is unfortunate. But so, and that's part of why, as a trustee, it's really important to understand what the legal process involves, because one of the things you can't do as a fiduciary is you can't just say, I didn't know. I didn't know that I was supposed to send a notice to the beneficiaries, because under California law, you're required to do that. So sometimes we'll get a call from a trustee who says, hey, I'm about to finish making final distributions and I just wanted to run this one thing by you. So then I'll back up and ask the trustee, okay, well, if you're almost done, did you send the notice to beneficiaries? What are you talking about? Did you meet with the decedent CPA to get their final tax return filed? No, I didn't know I had to do that. So just know that when you do agree to be a trustee, California imputes on you the same knowledge that they impute on me as an estate planning attorney with 22 years experience. But the nice thing is, these documents all have language in them that says that if you wanted to consult with an estate planning attorney, hire a CPA for the taxes, you have permission under these documents to hire whatever professionals are needed. And the decedent's monies are going to pay the fees of those professionals needed to help you basically do the trust administration. So I would encourage anybody who's named as a trustee to use some of the monies to talk with a professional, have them review the documents, have them explain to you what your questions, take notes. In the future, when things come up, circle back and ask more questions, because you can't in a court of law say, Your Honor, I didn't know. How would I know that? I don't have a law degree. I'm not an estate planning attorney. But that's where the courts would expect you in those situations to consult with an attorney and to use the money from the decedent's estate to pay that attorney's fees. I find that people don't generally need a lot of my time because most of this is pretty common sense. So oftentimes people will just have us help with the notice. They'll help us communicate with beneficiaries because sometimes they just don't want to be the liaison between them and the beneficiaries. They like us being that third party liaison. I'll be honest, I do feel that sometimes beneficiaries behave better when there is a professional involved, and that can make the trust administration a little easier, which makes everybody's life a lot easier. So then in the trust administration process, you've gone through the house, you've invited the loved ones to come in, they pick and choose the items they want, you document all of that. Now what you're going to do is you're going to prepare a document called an accounting. So an accounting is basically a memorandum that you're preparing for the beneficiaries that's going to show them from the date that this loved one died, here's all the assets that were in the estate, here's the debts that have been paid from the estate, here's the amount of money we paid an attorney, here's the amount of money we paid the CPA, here's the amount of money we paid in state and federal income taxes, here's the final net value of this estate, here's what each beneficiary we anticipate will receive as a final distribution. So the accounting is one of the most important documents that a trustee prepares, and they're basically going to start that memorandum at the beginning of the trust administration and just keep adding to it throughout the process of the trust administration and document when assets come in, when debts have paid out. And then the trustee is going to send that accounting to all the beneficiaries. With that accounting, you need to include additional paperwork to substantiate all of the information in the accounting. So it's not uncommon to include a house appraisal, receipts, bank statements, credit card statements, investment statements, canceled checks. And then as a fiduciary, when a person creates their estate plan, they do have the option of paying a loved one compensation for their time and trouble in being a fiduciary. Under California law, reasonable compensation is deemed to be 1% of the gross value of assets that you're managing. If you are a trustee and if you decide to take that compensation, which I would encourage people to take as you are doing a job and it is a lot of work, you do need to include that compensation as an expense on the accounting so that the beneficiaries can see that you are taking that. When you agree and accept compensation because you are being paid for ordinary services, it is taxed to you as taxable income. So that is something that you have to report on your tax return. Sorry, somebody just posted something on the chat and I wasn't able to read it. So let me just look at that real quickly. It says issues of concern with the fiduciary. I have continuity, especially with a single practitioner, and trustworthiness. How do you feel about having a professional and a friend as co-fiduciaries? Well, that's a great question. So my response to that is, and this is my personal opinion, you could probably poll 10 other attorneys and we would all have different opinions about this. But based on my experience, I personally find that having co-trustees is not very effective. And the reason I feel that it's not effective is because in my experience with working with co-trustees, inevitably one person is the heavy lifter and the other person is not. So when the person who's the heavy lifter who's doing all the work is constantly having to like fill in the other person and run things by them, it does slow the process down and it can be very frustrating for the person who's actually doing all of the work. So in some situations, if you have two people who know each other, because generally people who don't know each other aren't going to work very effectively together because they don't have that relationship or foundation. But if you had two adult children, for example, as co-trustees, that sometimes can be efficient if maybe one of them is more of the paper detailed person and the other one is more of the monetary numbers person. Sometimes a co-trustee partnership among two people can be advantageous when they bring different skills to the table. But in my personal experience, I find that in most situations when I've worked with co-trustees, I'm talking to one trustee all the time and the other one is totally not in communication. And the tricky thing about a co-trustee is the law imputes all of the liability on the two of them equally. So if I'm a co-trustee and the other co-trustee does something without my knowledge and it's a terrible thing that they did, I can be sued too, like I had done it. So the liability side of being co-trustees, I don't think is quite right, but that's what the law is. If somebody ever named me as a co-trustee for that one reason alone, I would decline it. I wouldn't be a co-trustee with somebody because I wouldn't want to take on their potential liability if they made a bad decision. So that's my personal opinion. As far as private fiduciaries go, I like private fiduciaries because unlike a corporate trustee, a private fiduciary is more willing to roll up their sleeves and really get involved and have a good relationship with the beneficiaries. So if you have a loved one who's on state or federal disability and needs somebody who's constantly checking on them, private fiduciaries have a really good bedside manner, at least most of them. I mean, you would want to interview the private fiduciary and make sure that you like them and that you have similar values and you like their bedside manner, because not everybody has the bedside manner. Sometimes you don't want the bedside manner. Sometimes you do. Every situation is different. But for example, if I didn't have a family member or close friend that I trusted to be a trustee, I would pick a private fiduciary to be my trustee if I had contingencies in my estate plan. So my estate plan has my kids getting money over a period of time, has drug testing clauses. It also has, I'll come back to your question in just a second. It also has a clause that beneficiaries have to keep their money separate property. So if they were to get a divorce, the monies that they inherited are protected. So when you have a private fiduciary, they are more than happy to roll up their sleeves and dive in and make all those contingencies happen. The nuance with the corporate trustee, and not that it's bad, it's just a nuance, is most corporate trustees don't want to exercise a lot of discretion, because when you exercise discretion, that's a gray area of the law, and that's where you have the potential to be sued. So I think if you had a choice between hiring a private fiduciary versus a corporate trustee, In making that decision, my advice would be is if all your beneficiaries are adults and you don't have age contingencies in place or drug testing clauses or any contingencies that you're worried about, then having a corporate trustee is great because they're licensed and bonded and they know how to be a trustee. They have deep pockets. So if they make a mistake, you can go after them. But if you have contingencies that you need to have be followed, whether it's somebody with special needs or somebody who's on disability, or whether it's a adult child who's not quite of the age of maturity that you're comfortable with them inheriting, so there's an age contingency in place, then in that situation where you have contingencies, I would prefer a private fiduciary over a corporate trustee, because the private fiduciary is going to roll up their sleeves. They're going to check on that beneficiary, have the communication. And I just think that that's a really important thing to note, the nuance between what a private fiduciary is often willing to do versus a corporate trustee. Okay, I'm going back to the chat because there was another question. So I'm coming to that. It says, for some reason, I thought you didn't need a trust unless you had assets of many millions. You were saying that anyone with more than 166,000 in assets that aren't POD or go to a named beneficiary, they should have a trust. That pretty much means anyone who owns a house in California. So yeah, the answer to that is you're exactly right. I mean, if I bought a house today and had no equity, I would need that house to be titled in a trust, or that house will go through probate when I die. So anybody who owns a house needs to have a trust, because if you don't have a trust, the house will go through probate. That's a public process, and your loved ones are going to pay a lot of money to go through that process, because those fees are already determined by law because they're statutory. But if you own a house and if you have your house in a trust, then you avoid probate, which means you save all that money in fees. Which the other benefit of having a trust is when you have trust, you have the ability to pick who your successor trustees are, and you get the ability to pick, who your beneficiaries are. And to me, I honestly don't know why you wouldn't want to have that power to make those choices versus leaving those decisions to the state of California. And I did just post my phone number and my email in the chat. So if anybody has any questions, or if anybody wanted to email me privately, I know sometimes people have questions that they don't necessarily want to discuss in an open forum. So feel free to call or email me at your convenience if you have any questions. But the other thing that you mentioned in that chat post is, if I have, let's say I'm 95 years old and I sold my house and I live in assisted living, so now there's not a house to worry about. And let's say I have $3 million. If I had the San Diego Zoo, for example, named as my pay on death beneficiary on my $3 million account, then that asset won't go through probate when I die, because when I die, the San Diego Zoo is going to present the bank with my death certificate and they're going to inherit that money. So not everybody has to have a trust when their net worth exceeds $166,250. And I realize that number is kind of arbitrary and random. But other states, like the state of Rhode Island, where my family lives, the number there is 15,000. So California is actually pretty generous in giving us a bucket of $166,250. So sometimes I have had clients that don't want to do a trust because they think trusts are complicated and they don't want to get into all that. So they'll name an organization as a pay on death beneficiary, but they still need to have a durable power of attorney. So if they lost capacity, they've got somebody in place to be their legal advocate. They would still want to have a medical directive. So if they couldn't make their medical decisions, the medical directive is where a medical advocate would be appointed. And ideally, you'd also want to have a will, because some types of assets like cars, you can't attach a pay on death beneficiary to. So, but that's why so many people, in California have trusts. It's not because they're millionaires, it's because they're homeowners. And sometimes they may not be homeowners, but they might have a pretty significant net worth. And other times people may not have a big net worth and they may not be homeowners, but they have little kids. So one other nice thing about having a trust is you can put contingencies in a trust that you can't do with a will, because a will goes through the probate courts and the probate courts don't get involved in drug testing and enforcing clauses like that, but a trustee can and will. So if you have the ARAG legal plan, which a lot of UCSD people have, you'll find that putting an estate plan in place is covered under your legal insurance. We accept ARAG. It's a great legal insurance benefit. It's a great company. I think that ARAG tends to have open enrollment in November. So if any of you have been thinking about getting ARAG, maybe now's the time to pull the trigger, because with all due respect, with this pandemic and COVID, estate planning is needed so much with making sure that you have all of your bases covered. And for those of you who have ARAG, who have an estate plan, you can use your ARAG insurance to do an estate plan review. You generally want to review the documents on a pretty regular basis, but the language in the documents does become stale, for lack of a better word. About every 8 to 10 years, you want to update the language because the tax laws change. And when those tax laws change, like with the retirement laws changing, that often will change the language in these documents. So from a legal context point of view, you do want to update the language in these documents about every 8 to 10 years. So for those of you who have an estate plan, I would encourage you to pull it off the shelf and look at the date. If it's been about 8 to 10 years or longer since you last did your documents, I would encourage you to do an update. And if you don't have an estate plan and you've always been wanting to do it, I would encourage you just to pull the trigger. I will tell you that we are super busy in November and October, because for our clients that have been wanting to do an estate plan, or who have wanted to do an update or review on their estate plan, life happens, people get busy, but then around the holidays when things slow down is when they decide, gosh, my insurance is coming due. I'm going to use it before I lose it. And that's the other thing about ARAG. The hours they're not cumulative. So it's a use it or lose it system. So if you don't use your hours in 2022, they don't carry over into 2023. So that's part of why we're also super busy in November and December.